All right, good afternoon, and welcome to this afternoon's final panel. The topic of this last panel is the United States and the ICC. As you know, an issue of some controversy in our political system, and debate and back and forth as different administrations of the United States government have taken different approaches or attitudes, from the Clinton administration's participation in the drafting of the Rome Statute, President Clinton's signing of the treaty on his last day before leaving office, the Bush administration's quote-unquote unsigning of the treaty, and then participation in or non-veto of Security Council referrals of situations, and going on to the Obama administration's current position. So we have, we're lucky to have with us a number of distinguished panelists to talk about the past, present, and future of U.S. engagement with the International Criminal Court. To my immediate left, we have Stephen Rapp, who is the Ambassador at Large for the United States on war crimes issues, and previously served in many different positions in the international legal system, most recently in 2007 as Senior Trial Attorney and Chief of Prosecutions at the International Criminal Tribunal for Rwanda, many other previous positions as well. To his left, we have Michael Greco, former president of the ABA and currently leading up the ABA's efforts to foster greater engagement with the ICC as part of its overall program in human rights and as part of its long-term engagement with the institution. And then finally, our own Professor Alan Weiner, who is no doubt familiar to many of you who are students here, but who prior to coming here to head up our international law programs also worked in the U.S. State Department, including at the U.S. Embassy in The Hague. So as with the rest of the panels, we'll have some presentations from each of the panelists. I'll maybe throw out a few questions, and then we'll open it up to the audience for further questions and general discussion. And so we'll begin at the far end of the table with Alan Weiner.
Okay, so we're in a very difficult position because it is the slot right after lunch. And under those circumstances, I am going to go ahead and move to the podium on the theory that it will diminish the chance that you will nod off. It will almost certainly eliminate the chance that I will nod off if I have to stand while speaking. So under Jenny's triptych, I am the ghost of tribunals past in the story. And so, as Jenny noted, before I joined the faculty here at Stanford, I served in the legal advisor's office of the U.S. Department of State for 11 years, and my last job was in the as the legal counselor at the U.S. Embassy in the Netherlands, where I was responsible for sort of the conduct of day-to-day relations, and I always stress the day-to-day part, and especially since we actually have somebody who was the person who I used to report to in Washington, or his successor. You know, the ambassador was in charge of overall policy on these issues, but I was just working the day-to-day issues on the ground, so dealing with the various international courts and tribunals in the Netherlands, including the Yugoslavia War Crimes Tribunal, the ICT-Y. I've really finished my job before the ICC came into existence, and so I did not have experience in dealing with the ICC as such, although I was involved in some of the negotiations leading to the establishment of the ICC. So when I think about what kind of relationship the United States should have with the ICC, it is largely shaped by my experience of U.S. relations with the ICT-Y. Now, I should note that the United States was a leading proponent of the creation of both the Yugoslavia War Crimes Tribunal and the International Criminal Tribunal for Rwanda. The United States was deeply committed to the notion that the atrocities that had occurred or were still taking place demanded international justice for a variety of reasons. We wanted to deter in Yugoslavia the commission of further abuses. Recall that the ICT-Y was established when the war in the former Yugoslavia, when the wars in the former Yugoslavia were still underway, to provide justice for the victims of atrocities, and ultimately we thought to provide a foundation for reconciliation between the warring communities. Now, for my post in The Hague, I was involved in the provision of a wide variety of forms of cooperation and support that the U.S. government engaged in for the Yugoslavia Tribunal. I'll just touch on these briefly to give you a sense of what the nature of cooperation really means. When we talk about cooperation between a government and a tribunal. So we provided a fair amount of investigative support for the Office of the Prosecutor of the ICTY. This would be a range of things. Sometimes an investigator would come to us and say, you know, we were interviewing some guys, and they said that somebody we really need to talk to, Joe Schmuckahukovich, has now relocated, and we think he lives in Detroit or Cleveland. Could you please help us find Joe Schmuckahukovich? And we would do that, right? So we would engage with the FBI with whatever biographic data that we had, and next we would try to locate these people for the ICTY. We would execute subpoenas. We would facilitate the execution of subpoenas on third parties for the ICTY. Other forms of investigative support involved U.S. government information of our own. So we had what we called a Rule 70 program in which we provided some of our own diplomatic reporting and also our classified intelligence information, which we would make available to the Yugoslavia Tribunal on a lead and background basis. The classified material we used to hold in our own embassy, and I used to receive a steady stream of visitors from the OTP, the Office of the Prosecutor of the Yugoslavia Tribunal, who would come to view materials. In some cases, we actually did some custom intelligence analysis of command and control structures, mainly on the civilian side, but also on the military side, to help the tribunal assess command responsibility cases. We provided witnesses, in some cases direct witnesses. Most of those witnesses testified in closed session, so I can't talk about them much more than that. We provided, in addition to our assessed contribution to the tribunal, we also made a series of voluntary contributions to support extra activities. When I got to The Hague in 1996, they had one trial underway and they had a single courtroom. Well, they were incredibly successful, and a bunch of guys started getting arrested and brought into custody. And then the ICTY realized, like, we still only have one courtroom. And we now have 5 or 6 cases that we need to try. How do we do this? The U.S. basically paid for the construction of a second courtroom for the Yugoslavia War Crimes Tribunal. It later added a third. We funded the initial public outreach program when we realized that this was a huge problem, that the message about what the ICTY was doing was not getting to the region, to the people in the former Yugoslavia. And above all, we provided political support. So when the Croatians would come to us and say, we have a new reform government in power now that Tudjman has died and fallen, and I will use air quotes around the phrase reform, we need you to give us some space on the issue of cooperating with the tribunal. That's very difficult for us. We can't really be expected to arrest our nationals and hand them over and provide information. So, Americans, can you go tell the tribunal to give us some space? And we would say, like, no, we're going to hold your feet to the fire. We're going to say part of your relationship with the United States is going to depend on your complying with your obligations to the ICTY. And these supported the overall policy goal of trying to end impunity for the atrocities that were taking place. Now, of course, the ICC is different from the ICTY in terms of the kind of relationship we might have with it. The main distinction, of course, is that the ICC could potentially exercise jurisdiction over U.S. officials and military personnel, whereas the ICTY could not, or so we thought. In fact, because the ICTY has jurisdiction over crimes committed on the territory of the former Yugoslavia after 1991, when the U.S. launched its major bombing campaign against Serbian targets in 1999 to halt Serbia's oppression of Kosovo Albanians in Kosovo, our planes, in effect, flew right into the jurisdiction of the Yugoslavia Tribunal. And there were allegations that arose that U.S. forces had committed violations of the laws of war during our 78-day bombing campaign, allegations of indiscriminate attacks resulting in the death of civilians, the use of illegal munitions. And the OTP, in fact, ended up conducting an extensive review of the U.S. bombing campaign. We won't talk about that more. Perhaps maybe it'll come up during the questions, but I want to make sure that I save time for my colleagues and for, above all, you. So let's go ahead and move on and accept the premise that there is no doubt that if the U.S. government were to become a party to the Rome Statute and to join the ICC, our nationals could potentially be investigated by, indicted by, and tried by the ICC, and it would not be in sort of this almost accidental way that the ICTY ended up with a potential jurisdiction over U.S. nationals. So what kinds of risks what kinds of risks let's think about this in cost-benefit terms. So let's first start with the costs, right? My wife always says, you always think about the negative. You need to be more optimistic. But it's how I roll. So I'm going to start by thinking about the potential downsides of participating in the ICC. So what are the costs of joining the ICC from a U.S. perspective? Well, in my view, the risk of indictment or prosecution of U.S. nationals is not purely imaginary, but it is a limited risk and it is a manageable risk. Given the complementarity regime, which we heard about this morning, it is unlikely, although it is not impossible, that U.S. military forces could be prosecuted for war crimes or crimes against humanity. I don't think we need to talk more about the complementary principle because I think it was discussed. Now, the key then is what is the U.S. record of prosecution, investigation and prosecution of its own forces when they commit violations of the laws of war? Well, I would say that the U.S. record of prosecutions has not been great, to be sure, particularly with respect to cases arising out of the so-called war on terror. That said, in more traditional armed conflict settings, the kinds of settings that would actually fall most likely within the jurisdiction of the ICC, the United States government at least tends to, and I want to say tends to, investigate allegations of mistreatment, violations of the laws of war by its forces. Now, even in the context of regular armed conflict situations, the principal method of accountability pursued by U.S. authorities is, and I want to call on Tori and cold call her in class because we just did that in class, but I won't embarrass her in that way any more than I already have. I should note that the Secretary of State is here as well, but we'll leave that for another time. In addition to the main method that we use for holding our forces accountable is essentially administrative kinds of discipline, administrative kinds of punishment. The results of military criminal justice investigative processes as a means of accountability, in contrast, have actually been quite meager. Now, according to a paper by Colin Call, during the period from 2003 to 2006, the U.S. military initiated some 600 investigations into allegations of misconduct by U.S. forces during the conflicts in Iraq and Afghanistan. Yet only 39 service members were formally charged in connection with the deaths of 20 Iraqis in the period from 2003 to 2006. These charges actually included only 26 murder or manslaughter or negligent homicide charges, and the legal process in these cases actually resulted in the end in only 12 prison sentences. Right? Now, Call estimates that perhaps as many as 70,000 Iraqi civilians may have been killed during the fighting in Iraq. I should stress at this point before I go further that it is likely that the vast majority of these killings occurred in connection with operations, lawful military operations, and would not, any reasonable standard, involve allegations of illegality or the commission of war crimes. But at the same time, the 20 killings of Iraqis that gave rise to the charges that are reported in the paper by Call are probably represent, in Call's words, a small portion of the incidents in which Iraqi civilians were killed by U.S. troops under questionable circumstances. So again, we see that our record of actually conducting criminal investigations into war crimes, at least those that would lead to criminal prosecution of the perpetrators, is a meager one. Now recall that the standard for rendering a case inadmissible under the complementarity standard is actually quite low. An investigation needn't result in a conviction. It needn't even result in prosecution, provided that the decision not to prosecute is made in good faith, that is to say, because the investigator finds that no crime was committed. That said, we must ask if becoming, it says so right here, we must ask if becoming a party to the ICC could increase the pressure on the U.S. government to become more active and more effective in carrying out investigations of alleged targeting of civilians during situations of armed conflict. And I think the answer is probably yes. It would create this kind of pressure. Now, is that a risk? Yes. Is it a risk that the United States government should avoid? In my view, the answer to that is no. We have obligations under international humanitarian law to investigate these kinds of activities, not to engage in unlawful killings of civilians, not to engage in indiscriminate attacks, to investigate them when they occur. And if our forces are violating these rules, in my view, the United States is best served by carrying out genuine investigations of them. As a colonel who's come out of counterinsurgency operation in Afghanistan, who now is actually in a research capacity here at Stanford, has said, whenever you ignore a breach of discipline or an offense, you set a new standard for your troops. That becomes the new standard. And by holding our troops accountable, we ensure that that does not become the standard. And I think that's the kind of way in which the United States wants to fight. So I see the potentially increased incentive or pressure for accountability that the International Criminal Court membership would produce for the United States would in fact be a positive and not a negative force. Even those who have opposed U.S. participation in the court on the grounds it exposes our soldiers to the threat of criminal prosecution would not argue, in my view, or I believe, that soldiers who should not be prosecuted at all when they commit violations of the law, of our law, in the context of military operations. Those opponents would prefer instead that any such violations be prosecuted by U.S. officials. That power, of course, would remain entirely in our hands if we were to become a party to the International Criminal Court. Now, apart from the focus on soldiers, the fear of the unacceptable risks of participation in the International Criminal Court, the source of our real exposure, up until Kampala, had always focused on our concerns about the crime of aggression, where, in contrast to our generally good record of compliance with the law of operational armed conflict, we have a much more legitimate worry. We have used force in circumstances, let's see, how shall I phrase this diplomatically? We have used force in circumstances in which many reasonable international lawyers would say that our actions were not compatible with the UN Charter's use of force regime and thus would qualify as aggression. Grenada in 1983, Panama in 1989, Iraq in 2003, some of our counterterrorism operations today in Pakistan, Somalia, and Yemen, and some people would even argue that aspects of the U.S. use of force in Afghanistan after 9/11 are problematic from an international law standpoint. But the definition of aggression that emerged from the negotiations in Kampala permits parties to opt out of the court's jurisdiction over a crime of aggression arising from an act of aggression committed by a state party if that state party has previously declared that it does not accept such jurisdiction. So the U.S. has the ability to ensure that the fear or the nightmare of the ICC indicting a U.S. president for the exercise of the most fateful sovereign decisions about the use of force will never be realized. Now, some in this room may regret this, but if we're thinking about the risks, I think they are certainly manageable from the standpoint of the United States. Now, there is actually one area of genuine risk, and that concerns military policy, not the actual conduct of operations at the ground level, but military policy, rules of engagement set at higher levels. So a couple of examples. During the 1999 Kosovo bombing campaign, as a force protection issue, U.S. pilots were instructed not to fly below 15,000 feet. Right, which was out of the range of Serbian anti-aircraft systems. Now, flying at 15,000 feet means your targeting decisions are a lot fuzzier, because you can't really see what you're shooting at as clearly on the ground, particularly when you're shooting at what you think are military vehicles. And there were some mistakes that happened. We targeted some convoys of Kosovar Albanians that maybe would have been avoidable had our pilots been willing to fly lower, right, assume greater risk to themselves. That's the kind of thing, that's the kind of decision that is a policy decision vetted by the policymakers and the lawyers. And it's very difficult for me to see the U.S. government, if some second party decides that that was not a permissible way of fighting under the laws of war, it's very difficult for me to see the U.S. government ever engaging in any kind of investigation or review of that decision. In the context of the Haditha massacres in Iraq in 2005, one of the things that we learned from the training that our Marines had received is if you take fire from a building, a house, it's okay to treat that house as a hostile object and destroy that object, right, without actually having to make investigations of who's inside and what the proportionality balance that might be implicated if you destroy that building. Again, if this is a rule of engagement that's been vetted by military lawyers, it's hard for me to see any possibility of review. And so that is an area where there could be tensions or exposures between U.S. warfighting techniques and what the ICC might conclude. Now, I actually think that this is one of the reasons why deeper engagement between the United States government and the ICC could be helpful by helping to bring to the ICC the U.S. perspective on the operational law of armed conflict during the stage of the investigations when the court is actually developing the legal theories upon which it might bring criminal charges. I'll say a little bit more about that in a moment. So now let me talk briefly about the benefits for the United States of participation in the ICC. First, I think joining the ICC would reflect an American embrace of a very laudable policy to support criminal accountability. It's been our policy in the past when we established the Nuremberg Tribunal, when we supported the creation of the ad hoc tribunals or the hybrid tribunals, and contrast that to the current policy of not joining the court because of stated concerns about the exposure of U.S. officials and soldiers. This sounds, to everybody, like we want a get-out-of-jail-free card, which in turn, of course, suggests that we know we're about to do the kinds of things that would otherwise land us in jail. Right? This is a deeply problematic image for us to present to the rest of the world. Now, in fairness, Ambassador Rapp is here. We've moved away from the most explicit forms of the get-out-of-jail-free policy. The Obama administration has effectively reversed the Bush administration's very vitriolic opposition to the court. It has engaged in discussions and is pursuing some forms of cooperation with the ICC, and I think this is a very commendable development. And under the circumstances, some have argued that actually there are a few additional advantages to be gained in actually becoming a party to the court, right, since we're already doing some forms of cooperation. Perhaps. But given that it is a deep value of the United States to oppose genocide, to oppose crimes against humanity and war crimes, this seems like a too narrow calculus. The same questions about the foreign policy benefits of embracing humanitarian values of the kind promoted by the ICC, I think, have arisen as well in the context of our relationship with the international human rights regime more generally. And I think the conclusion in that context has been that U.S. credibility in calling for other states to respect human rights is enhanced by our own participation in the human rights system. In the same way, our credibility in condemning atrocities committed by the past government in Libya or by the present regime in Syria loses some of its force and is susceptible at a minimum to snide comments that we're a country of double standards if we remain outside the court. I think there are also some pragmatic operational policy benefits to be gained from deeper U.S. engagement with the ICC. If the U.S. were to become a party, it would be easier for the U.S. to make available current and former U.S. government officials to serve on the staff of the ICC to help, now I have to use my terms very carefully here, to help influence and shape investigative and prosecution theories. Now, I want to stress that what I have in mind here is not the sinister or nefarious kind of influence or shaping where U.S. government employees are carrying out, are acting upon instructions, policy instructions from Washington. I have a very different view. Rather, there are many lawyers, particularly those who do not have operational experience in the law of war, and this touches upon a theme that Professor Wedgwood mentioned in her opening remarks today, who tend to view the law of armed conflict rules almost as if they were just human rights norms. That is to say, if they were meant only to protect victims of war. But this point of view does not recognize that those rules also confer important rights on states during times of armed conflict. Deeper U.S. involvement can help to ensure that the ICC interprets and promotes the development of IHL in a manner that's most consistent with an interpretation of that body of law that combines both our humanitarian impulses with operational pragmatism. I saw this in very clear ways in my experience with the ICTY. When the ICTY was initially doing its investigation of the Siege of Sarajevo case, there were some theories that the OTP was developing that would have basically criminalized what turns out to be standard artillery procedure for most NATO armies. Because civilians were being killed by shells, OTP lawyers were assuming that the firing was indiscriminate, right? And with the involvement of NATO, including an American military analyst, I think the OTP was able to rethink the strategy. It didn't preclude the OTP from deciding that the Siege of Sarajevo was a subject appropriately for indictment. And in fact, Generals Milosevic and Galic were indicted in that case, right? But I think it helped refine or at least harmonize the OTP strategy with the way that operational military lawyers think that these rules should function. All right, so even if our goal is to limit exposure of our troops and not to promote principles of justice, accountability, and rejection of impunity, I think interdependence between the United States and the ICC is the best approach. So, in conclusion, in my mind, the case for closer engagement and even becoming a party to the Rome Statute strikes me as a strong one, even for those who don't see the matter strictly in terms of humanitarian considerations or human rights matters, but just as a straight foreign policy, national interest kind of determination. The case is stronger still when one adds the powerful argument that U.S. engagement with the ICC has the potential to promote long-standing American values and policy goals of strengthening accountability and preventing the most serious violations of international humanitarian law. Thank you.
Next hear from Ambassador Rapp, who will speak from his background as prosecutor for the Special Court from Sierra Leone and at the ICTR, as well as currently representing the United States on these issues.
Okay. Well, thank you very much, and thank you, Alan, for inviting me and for those remarks. I think I'd like to start this where you started and to follow along in terms of how our U.S. involvement with the ad hoc tribunals really informs the approach that we're today taking with the ICC, what we're doing in fact, and where we may be going in the future. As has been indicated, I worked at the ad hoc tribunals and hybrid tribunals for 8.5 years, the first 2/3 of that time in Arusha, prosecuting those responsible for the genocide in Rwanda, the murder of 800,000 men, women, and children in the course of only 100 days. And then the last third of that time in Freetown and in The Hague for the Special Court for Sierra Leone as chief prosecutor in the cases, the historic cases in Freetown, but also beginning and finishing the prosecution case against Charles Taylor. These institutions, I think, have left a powerful legacy and raised expectations, I think, across the globe of the possibility of justice and of the idea that people at the highest level, presidents, prime ministers, military leaders, cabinet officials, leaders of the media like those that I prosecuted in Rwanda, that those kind of individuals can be brought to justice. And everywhere I go in the job that I now am in, and I travel 222 days a year, and it's in 48 different countries. It could be Bangladesh dealing with what happened in 1971. It could be on the borders of Syria and Turkey and Jordan today, dealing with the ongoing atrocities in Syria. I talk to victims and they say, you know, is our blood not red? We've experienced murder and rape and atrocities on a mass scale. Where are we going to achieve justice? And I think we've learned a lot from what happened at the international courts. And some who've talked about speed of trials and other things, I think should take a good look, because these institutions are closing. It's true, as someone said, that in the near future, the only purely international court in the world will be the ICC. But they are finishing. On May 16th, they'll begin the Mladic case. It took forever to get Mladic to justice. He became the 160th person brought to justice. A few months later, the 161st out of 161 that were charged by the ICTY were brought to justice. That case begins on May 16th. It's a complex case. The prosecutors shrunk it down to about 30% of what he wanted to present. The judges are insisting that the prosecution case be presented in 200 hours. The prosecution has agreed, but says we'll need to do more documentary evidence. The court's saying, no, we're not going to allow any statements longer than 50 pages. I mean, they're doing everything, I think, to expedite these proceedings. A lot has been learned at these courts. And in the complementarity area, we look what's happened in the former Yugoslavia with the prosecutions, not just in Bosnia, but also in Serbia and Croatia of their own. A lot of the legacy of why that's happening is because of what the tribunals have done, and we now have transfers of cases even to Rwanda as they've built their capacity. So there's a great lesson to be learned. I've been on several panels recently. I was one out in Australia on the ICC-its a month or so ago, and there were a number of people who came forth and sort of gave this sort of competition between, oh, well, look at what the ad hoc tribunals have done, all the big shots they've got, and then let's look at the ICC, only 6 people arrested and 1 guy for child soldiers in 10 years. And I got up and frankly refuted that. I said, these, to me, are part of the same project. This is part of meeting the expectations for justice across our globe. And outside the rooms of people that follow these things, there's really no great understanding that this isn't just one institution, that people aren't facing trials at The Hague for whenever the crimes are committed. I'm reminded of that in the context of the Charles Taylor case. As you may know, because of the attitude in the region, particularly by President Sirleaf and by President Obasanjo, they didn't want that trial in Freetown. So we transferred it to the ICC. And I became, for 2.5 years, a tenant of the ICC, trying the Charles Taylor case in a courtroom until they finally booted us out because they finally got enough action that they needed both of their courtrooms. And fortunately, we were able to move into the courtroom of the Special Tribunal of Lebanon that had just been completed. But I always said to Luis Moreno Ocampo, it doesn't make any. How many times we put out a press release saying that this case is tried by the Special Court for Sierra Leone, by judges from Africa, by a hybrid court. They're still going to report in the news. Today at the ICC, Charles Taylor was on, answering Naomi Campbell, et cetera. And then, of course, I was there last on the 26th of April. Conviction on all 11 counts, very happy. Later that night, I'm walking down Denaweg, and I happen to look to my right into a bar, and there's nobody in there except for a guy in scruffy clothes, and it's Luis Moreno Ocampo, and he's watching a soccer game. And I've been reading reports on my BlackBerry. ICC convicts Taylor, and I said, Luis, I was absolutely right. I want to congratulate you on this verdict. But indeed, I mean, the perception is that this is an international project to bring these individuals to justice across the globe. Now, as far as our American attitude, and consistent with the principle of the ICC of complementarity, the best place for justice is closest to home, closest to where the crime happened, closest to where the victims live, closest to where the message of that trial can be heard loud and clear by the affected communities. But sometimes that's not possible. And when it's not possible, and you can't get there by international assistance or international participation, we recognize that you need to have an international court of last resort. And the existence of an international court of last resort can provide a further incentive for countries to do it on their own. And the United States, in 2 administrations, Bush administration during its second term in 2005, and this administration recognized that where justice isn't otherwise possible, the ICC is an appropriate place for that justice. Now, I want to talk about the U.S. We heard it was complicated relationship with the ICC, and just quickly, we've heard some of it already. What happened in 2001 as the ICC was moving toward 60 ratifications and coming into force. At the same time, the United States was attacked on 9/11 and was beginning its response to Al-Qaeda and to terror. You had the famous unsigning. It's really a so-called unsigning because it's not really that, letter by Undersecretary Bolton. You had Congress passing a law in 2001 that said that the U.S. could in no circumstances provide funding to the ICC. You had in 2002 the famous American Service Members Protection Act. How could anybody vote against a bill called the American Service Members Protection Act? And 80% of members of Congress voted for it. In Europe, they called it the Invade the Hague Bill because it did actually give the President of the United States authority, if he needed it, to invade any country in order to spring any American that might be charged by the ICC or anybody working with us. And so there was indeed an effort in the early days of the ICC to strangle this court essentially in its cradle. But by 2005, when you had the horrors of Darfur, and when Secretary Powell had called it by its proper name, a genocide, and when there was no place else that justice could be delivered, the Bush administration decided to go along with the referral of that case to the ICC. And that, in fact, is the great moment of change. And whenever anybody tells me we shouldn't do anything for the ICC, I say, well, that decision was made in 2005. It's done. we decided this was the place where justice could be achieved. And frankly, if you follow the Bush administration strategy up to 2008, I remember in July when Louise sought the arrest warrant against Bashir, and a lot of countries were very concerned about that. There was a resolution in the UN that was in regard to the peacekeeping force there, and it included a mention of the fact that the Bashir case could be deferred by the Security Council. The United States and the Bush administration was so opposed to deferring that case that we were the only country in the Security Council to not vote for that resolution. We abstained from that resolution in July of 2008. So we had come, by 2008, a long way. You may also know that the United States, and this to some extent was mandated by a section that was in the American Service Members Protection Act, but later removed, insisted that countries around the world sign agreements that they would not surrender an American to the ICC. And the law and policy made that a condition. If they wouldn't sign such a thing, unless they were a NATO ally or a major non-NATO ally, I think that's Australia, Japan, Korea, and Israel, I think, but any other country that didn't sign it, we had to cut off all military contact and assistance. And the administration spent a lot of effort negotiating these agreements with countries that had never had an American service member in their country. Now, understand there's a reason why this is consistent with status of forces agreements to a point that when we send people to a foreign country in a challenging situation and where they may have a legal system where people aren't going to get a fair trial, we insist that we're going to try that person ourselves. So it was consistent with that, but it didn't just say service members, it said any American. And a mercenary, a freebooter, an arms trader, et cetera. If a country didn't agree to give that person up, we wouldn't aid them at all. By 2007, Secretary Rice said this is shooting ourselves in the foot. We couldn't even engage in discussions with New Zealand as a result of this. And so the administration made the position clear that we weren't going to negotiate these things anymore. Now, they haven't been taken off the books. They're still there. But the provision of the law that said that we had to have them as a condition, the administration asked that it be repealed, and it was repealed. That brings us up to where we are in the Obama administration. And as many know, we made the decision to begin participating in ICC assemblies of state parties as an observer, something that we were entitled to do by the fact that we were present in Rome and signed the final act. That doesn't mean signing the treaty. We've signed the minutes that we've been there. And any country that did can go there. China went all during the first decade of this century. They went to the Assembly of State Parties as an observer. Russia did. China's never signed it. Russia did sign it. But others have participated. We stayed away. In November 2009, I was proud with Harold Koh to lead the first delegation by the United States of America to the ICC as an observer. And in each of the last 3 sessions, plus the session in Kampala, where amendments were considered and other aspects of the court's work were considered in 2010. The United States has been there participating and basically stating our willingness to assist this court. We've also established a policy consistent with our law of cooperation and support for the court's prosecutions. How can we do that with the American Service Members Protection Act? There is, I talked about how the law had this rather clever title for its supporters. Senator Dodd, who's no longer in the Senate, Chris Dodd, sponsored an amendment to it that was also impossible for people to vote against. That's the last section that basically says nothing herein shall prohibit the United States from assisting in the case of a non-citizen, such as Slobodan Milosevic or Saddam Hussein, or any other person who may be alleged responsible for genocide, crimes against humanity, or war crimes. Of course, that's everybody the ICC has charged. And so that does allow us to assist. And even though it's not become public, we have an opinion from the Department of Justice that allows, read with that law that says we can't directly fund the ICC, it allows us to provide in-kind assistance as long as we do it in a way that's not inconsistent with some of the specific prohibitions in the American Service Members Protection Act. So we've been meeting with Silvana, we've been meeting with Luis, I'm meeting regularly with my friend Fatou, who's been suited, the new prosecutor, will take over on June 16th, who's a former member of my team in Arusha, and talking about ways in which we can help the court in its prosecutions. And basically, though people had been worried that this court would take cases that weren't justified, take cases that were politically motivated, our evaluation is that the cases that this court has taken are cases that have cried out for justice. Cases that weren't being done and couldn't be done really at the national level at the time that they were taken, and they involved intentional attacks against civilian populations, not collateral damage, not some sort of a question where there might be some kind of debate about who they were going after. They involved horrendous atrocities, and for that reason, we support them. Now, our law says we have to make that analysis on a case-by-case basis. We make an agreement, if it's possible, across our interagency process, and then we look for ways to assist. One of the ways that we're doing that, we can't talk about the specifics, is in witness protection and relocation issues. And I think it's fair to say, I'll leave it to my friends in the ICC, but in terms of responding to the requests of the ICC, and you heard from Silvana how difficult it is to get agreements, we're probably doing more than any country in the world and any state party, I think, to assist the ICC with some of the more challenging issues they have on the witness protection front. Fugitives, in this administration, we've given a high priority to fugitives of the war crimes tribunals, and in my first couple years, it was Hadjic, Mladic all the time. It's still Kabuga, Mparanya, Bizimana, the last of the fugitives sought by the ad hoc tribunals. It's a very high priority, but we have a program to go after these fugitives, including major fugitives of the ICC. Someone mentioned rewards for justice a little bit ago, and this is probably one of the more interesting things about the American political system and the possibilities of ways that we can cooperate. We do have this rewards for justice program. Understand that's not the Yugoslavia, Rwanda, or UN program. That's a US program. In America, we love rewards, reward posters, and it's something that members of Congress will support. We've got one for international organized crime. We've got one for counterterrorism. We've got one for war crimes, but it explicitly is for the Yugoslavia, Rwanda, and Sierra Leone courts. Since becoming war crimes ambassador, I've authorized 14 rewards. Up to, it can be up to $5 million, but the highest I paid was $2 million for people that assisted with various arrests for Yugoslavia and Rwanda. But the law specifically includes these tribunals. We now have legislation this administration is supporting that would take out the names of the tribunals and say it could be for information leading to the arrest and transfer, alive, of any, now it's not dead or alive, but arrest and transfer of any person charged with genocide, war crimes, crimes against humanity to an international, hybrid, or mixed court. Now, it doesn't say ICC, it doesn't say any court. But then it also says, and as we've been working with the members of the Hill, it will have to provide that we'll need to give notice to Congress, maybe even on a confidential basis for 15 days, indicating who we might be adding. But everyone understands what this is about. This is about Joseph Kony. This is about Adhiambo. This is about Dominic Ongwen, the three ICC fugitives of the Lord's Resistance Army. And even before the famous Kony 2012 video went viral, members of Congress were lining up to sign this. Well, since that happened, it's an amazing list of members of Congress who are now sponsoring this legislation. We have Congressman Burton of Helms-Burton fame. He's a sponsor of a bill. The one that's the most exciting, Eliana Ross-Lehtinen, Cuban-American congresswoman from Miami, now chair of the powerful House Foreign Affairs Committee. Back in May of 2010, I don't know if you remember this, Ben, she and several others sponsored a bill called the Protect America Act that would have prohibited Harold Coe and I and our delegation from going to Kampala. Now, fortunately, she didn't get a lot of support. It didn't pass. We went to Kampala. She is now sponsor of a bill that will allow us to pay a reward up to $25 million for the arrest of Joseph Kony and his delivery alive to the International Criminal Court in The Hague. Now, it's not law yet. Congress has a hard time passing laws, but this is one that is so bipartisan that I think we'll probably get the job done in the next few weeks. And there's a companion legislation in the House, in the Senate. So these are the kind of ways that we can assist this court. There are other possibilities. I mean, if the court needs a team to dig mass graves. I mean, I'm not suggesting that we'll say yes, but in kind, doesn't, it's case specific, it's technical, it's something Americans could do. Those kinds of questions put to us are questions that we'd welcome and we'd give an answer to. So I think there's a lot of potential for us assisting. Then the question is, and the one that Alan focused on is, well, if you're ready to go wading, why don't you go swimming, Why don't you get involved and become part of the ICC? Well, there's the practical answer. As you know, the United States, as all of you know, takes a very long time to join international conventions. It took us 40 years to join the Genocide Convention. That was a close-run thing in the end. It was only when Reagan went to Bitburg and Elie Wiesel and others started raising the issue, and he came back and said, let's do something, that he was able to turn that into an issue on which there was Republican leadership and get that through Congress and get it enacted. Wilson went to Paris and got the rest of the world to agree to the League of Nations and couldn't get it passed in the Senate. The favorite example we all have, and those in law school have read the juvenile death penalty case, which talks about executing people under 18, who committed their crimes when under 18, that violates the Convention on the Rights of the Child, but as was pointed out by Justice Scalia in his dissent, the United States hasn't ratified the Convention on the Rights of the Child. Indeed, the United States and Somalia are the only two countries in the world that haven't. And fortunately, the Supreme Court by 5-4 made the right decision based upon the 8th Amendment, but not on the basis of the Convention on the Rights of the Child. So the United States and Somalia. But I do have some more news on that. The Somali Transitional National Assembly doesn't meet in Mogadishu. It meets in Nairobi and gets paid by the international community to do so. Do you know that they recently ratified the Convention on the Rights of the Child? So now the United States is the only country in the world that hasn't ratified it, and I don't think there are 67 votes in the Senate to do so. Though in that regard, I should say I was a few months ago talking to a good friend of mine at the international level, Nabi Pillay, who was the presiding judge in the media trial that I led in Arusha, went to the ICC for 6 years and is now High Commissioner for Human Rights in Geneva. And I was lamenting the difficulty we have in America with these conventions. And she said very kindly, well, but you Americans protect the rights of the child so much better than many of the countries that have ratified them. And indeed, that goes to the heart of the American experience, that we have our 8th Amendment upon which to knock down juvenile death penalties. We have our own traditions and systems that we're very proud of, and it's a very hard thing to get Americans to adopt international conventions or submit themselves in any way to decision making that's outside of the American polity. So we know what a challenge this would be. We also know the politics when we even have people like Senator Lugar, who is one of the few people who would support some of these ideas, not the ICC, but some international treaties, being defeated. It's hard to get to 51 votes, almost impossible now to get to 60 to break his filibuster, but to get to 67. Harold Coe, my colleague, the legal advisor, former dean of Yale, loves to tell a story about his own appointment as legal advisor. He had he was endorsed by every legal advisor, right, left, center. He had a letter of endorsement from Ken Starr, but they filibustered him in Congress. And with the help of Lugar and a couple of Republicans, he finally got the filibuster broken with 63 votes and was confirmed as legal advisor, an executive appointment in the U.S. Department of State. And Harold says, if I'd been a treaty, I'd been beaten. So, we have a hard, it is a hard standard to meet. That said, this administration is not saying at this time that we want the Senate to move in this direction. And so we can't say this is solely because it'd be hard to do. though obviously you don't ask to do things unless you think you've got a chance of getting them done. But there is and there remains concern of the kind that Alan was concerned about. And what I think a lot of us are hoping is that as a result of our engagement with the ICC, as a result of the assistance we're providing and the regular consultation and discussions about the ICC cases, preliminary examinations, et cetera, we can overcome some of these doubts and move closer. The concern, I think, that remains that has a sliver of validity, at least in theory, is the possibility that Americans who, after all, are out there, 3 million strong men and women across the world, in our view, protecting people from terror and atrocity, might find themselves subject to an unfair prosecution. Is that a real risk? Alan mentioned the Yugoslavia example, and let me just dig into that for just a moment. When we engaged with NATO in the bombings in Kosovo and Serbia that stopped the ethnic cleansing and succeeded in stopping an atrocity, there were more than 24 incidents in which civilians were killed, including people at the radio station in Belgrade, including people at the Chinese embassy in Belgrade. And Carla, then later my boss, but then in '99 she just become prosecutor of the ICC-Y, said she had jurisdiction. And she appointed a Canadian military lawyer who evaluated every one of those incidents and came back with a report saying they were targeting military targets, the force used was proportionate. We don't find that there's a threshold case here sufficient to open an investigation. And so case closed. Well, if you've read Carla's book, my Madam Prosecutor, and it does deal with some of the cases in which I was involved, but she said she was unhappy with that decision because she wanted to prosecute an American. That would have really looked good. And she said she was hoping that before she quit, she'd had a chance to do that. And she was talking to one of the judges, whose name remained nameless, a good friend of mine, and said, yeah, you need to prosecute an American to show your independence. But if there's no case, if the things the Americans did were within the laws of war, then why do that? And I think there is always that concern that prosecutors, in order, under the political pressure to say, aha, I'm tough, could do that and unfairly target us. On the other hand, the ICC does have even more protections than the ICC-Y did. And there is complementarity. And we are, I mean, it's imperfect, but we are proud of our military justice system. I mean, Sergeant Bales will, I'm confident, receive a fair trial, and the evidence against him is very strong for the killings. There were earlier prosecutions of people in the Stryker Battalion that were involved in intentionally killing civilians that have been sentenced to long periods of time. Bill Lietzau, that we heard about earlier, is an American colonel in the JAG Corps that now is the Deputy Assistant Secretary of Defense, played a key role in Rome in writing Article 8 on the ICC war crimes, actually was the author of the ICC Elements of Crimes. People turn to him and says, because you Americans know more about this area and how to do it than anybody in the world. So I think we do have a pretty good system. But, and the Article 8, if you look at it, says these crimes particularly if conducted on a widespread basis. And so that they're not going to be, people aren't going to be prosecuted on one mistake, one incident, but only on a widespread pattern of conduct. Now, it doesn't say for sure, it says particularly. But to the extent that the standards of admissibility make it clear that the people you're prosecuting are those that are going out as a matter of policy and targeting civilians, I think is something where greater legal assurance can be provided in the future. And then, of course, one has complementarity. You can do it yourself. And that's something that I think we'll do no matter what. And the position that I always take, and obviously it may be challenging in terms of some of the things that happened in the last administration, but I can speak only for this one, but that our position is that the United States will prosecute people who commit these crimes and will never whether we're in the ICC or outside the ICC, give reason for any, properly motivated prosecutor to seek to the admissibility of a case against an American citizen. So as we make it clear that that's our policy, as we develop our relationship with the ICC, I think there is the possibility that over the course of not necessarily just years, it may be decades, the United States could move to a situation of coming in. But we're a long way away from that right now. Anyway, though fundamentally, we're going to be working with that court. We want it to succeed. We also want national systems to succeed. Complementarity is one of the greatest principles there ever was. I mean, it's a strange word, but it fundamentally means let's focus on getting these cases prosecuted at the lowest level possible. But let's get justice for the victims, because that's what all the work in which Americans have taken leadership from Nuremberg and in the ad hoc tribunals has led to, an expectation that when these crimes are committed, there needs to be justice, and an expectation that can build us toward the kind of deterrence that Ben was talking about, that will indeed prevent other people from becoming victims of genocide, war crimes, or crimes against humanity. Thank you very much.
Now we'll hear about the American Bar Association efforts to encourage U.S. engagement with the ICC.
Well, good afternoon, everyone. When I learned that I was going to be the last speaker, it put me in mind of the man who was invited to speak at a gathering like this. And when he accepted the invitation, he was quickly told that he would have 5 minutes to speak. And the man responded, how can I possibly tell everything I know on this subject in 5 minutes? The answer was, speak slowly. I will speak quickly because it's the end of the afternoon, and we're mindful that what stands between you and those doors are the last speakers. Well, I am very honored to participate in this important ICC conference on behalf of the American Bar Association Center for Human Rights, which I'm proud to chair. I want to thank, since the ABA Center for Human Rights is a co-sponsor of this conference, I want to be sure to give my thanks to some individuals. First, I start with Stanford Law School and Dean Larry Kramer and Professor Weiner for bringing us all together here. To the esteemed ICC officials who honor us with their presence, having traveled a long way. To the eminent Ben Ferenz, a pioneer and champion of international criminal justice. To Ambassador Stephen Rapp, a wise and skillful leader in this vital field. To Professors Kay, Martinez, Stacy, and Wedgwood, whose scholarship and commitment to international law both enlighten us and inspire us. To Sam Shomanesh, who you heard the ICC's liaison and consultant to the ABA Center for Human Rights on our International Criminal Court project, which is the subject of my remarks today. I thank everyone else who has contributed to making this conference possible. On November 21, 1945, in the Palace of Justice at Nuremberg, Germany, U.S. Supreme Court Justice Robert H. Jackson, as Chief Nuremberg Counsel for the United States, made his opening statement to the International Military Tribunal in case number 1, entitled "The United States of America, the French Republic, the United Kingdom of Great Britain and Northern Ireland, and the Union of Soviet Socialist Republics versus Hermann Wilhelm Göring et al." Justice Jackson, in his opening statement, said this: "The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility. The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored. because it cannot survive their being repeated. That four great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. The Third Reich may indeed have been the most malignant and devastating regime in world history. Yet, out of the carnage, the ashes of World War II, arose the Nuremberg trials. And these great human rights achievements, the Universal Declaration of Human Rights, the Geneva Conventions, the Genocide Convention, and the broader international legal framework under which we live and operate today. Nevertheless, the latter half of the 20th century, despite adoption of the Universal Declaration of Human Rights and other important international instruments, was nearly as bloody as the first half. Genocides in Cambodia, Rwanda, Bosnia, and Darfur are just several nations flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. The Third Reich may indeed have been the most malignant and devastating regime in world history. Yet, out of the carnage, the ashes of World War II, arose the Nuremberg trials. And these great human rights achievements, the Universal Declaration of Human Rights, the Geneva Conventions, the Genocide Convention, and the broader international legal framework under which we live and operate today. Nevertheless, the latter half of the 20th century, despite adoption of the Universal Declaration of Human Rights and other important international instruments, was nearly as bloody as the first half. Genocides in Cambodia, Rwanda, Bosnia, and Darfur are just several among too many examples of atrocity crimes that have riddled recent decades. Those horrific crimes have proven that pledges of, quote, never again, close quote, no matter how sincere and solemn, mean little without a credible and permanent force of justice for those who kill en masse. Indeed, these repetitive cycles in human history, massive destruction and depravity, followed by righteous indignation and reform, followed by yet more depravity and paralysis, demonstrate that eloquent pledges and proclamations are not enough. The words, indeed the imperative of never again, must not merely be set to paper and left to politics, but must be institutionalized under a just rule of law. To that end, the American Bar Association in 1978 called for the creation of such an institution, a permanent international criminal tribunal dedicated to ending impunity for atrocity crimes, to securing justice for victims, and by so doing, to deter future atrocities. 20 years later, the ABA in 1998 was among the key NGOs involved in developing the Rome Statute that established the International Criminal Court. And since 1998, the American Bar Association has been calling for U.S. accession to the Rome Statute, and until that happens, for U.S. engagement with and support for the work of the ICC. This year, having declared repeatedly its strong support for the ICC, the American Bar Association, through the ABA Center for Human Rights, has determined to institutionalize its commitment to international criminal justice. I'm therefore pleased to announce the decision of the ABA Center for Human Rights through its new International Criminal Court project to transform longstanding ABA policy into concrete action. The ABA's ICC project, to be formally launched this fall, will foster greater U.S. engagement and cooperation with the ICC in 3 ways. First, by promoting practitioner engagement and training. The Center's ICC project will convene in-person and online best practices conferences, as well as training workshops for U.S. and international criminal law practitioners. The project will also marshal the resources of the ABA and its partners to help train ICC lawyers and staff. Legal exchange missions to the U.S. by international lawyers and judges, and to The Hague by U.S. lawyers and judges will be organized. The Center will work closely with Madame Registrar Silvana Arbia in these training efforts, which have been formalized through an exchange of letters between the Center and the Registry. Second, the ABA's ICC project will facilitate direct engagement among and between U.S. and ICC officials. The project will establish venues for ongoing dialogue and debate among ICC officials, U.S. policymakers, and stakeholders. One such forum, for example, will convene American proponents and opponents of the ICC to discuss U.S. policy toward the court and ICC-related current events. Another forum will compare and contrast features of American and international criminal prosecutions, such as investigation methods, evidence discovery, and evidence preservation and presentation, pretrial detention, examination and cross-examination of witnesses, and appellate procedures. Another will explore the policy reasons why support by the U.S. government of an effective criminal justice system internationally serves the interest of the United States and the American people. The project will also facilitate private meetings between ICC and U.S. officials that we hope will build mutual trust and understanding. And third, the ABA will advocate for the ICC publicly and before the U.S. legislative and executive branches. The ICC project will deploy ABA members and other representatives of the legal profession to advocate for greater U.S. engagement with and support for the work of the court in protecting human rights, eliminating impunity for genocide, crimes of humanity, against humanity, and war crimes. In addition, the Center's ICC project website will demonstrate the project's multilateral approach to U.S. ICC relations and will help to improve understanding of international criminal law and the ICC's role. Among other features, the website will publish expert commentary on relevant issues of the day and will serve as a repository of international criminal prosecution and defense best practices that emerge from the project's collaborative activity. To guide these efforts and to maximize their impact, the Center is assembling what must be and will be a bipartisan ICC Project Board of Advisors comprised of eminent leaders in international law, diplomacy, and advocacy. I'm pleased to inform you that to date, the following individuals have indicated their willingness to accept appointment to the Board of Advisors: Justice Sandra Day O'Connor, Judge Patricia Wald, Judge Thomas Bergenthal, Ambassador David Sheffer, Ambassador Thomas Graham, Ambassador Thomas Siebert, Ambassador Hans Corell, Professor Emeritus of Law M. Sharif Bassioni, former State Department Legal Advisor William H. Taft IV, former State Department Legal Advisor John Bellinger III, and Director of the Planethood Foundation, Donald Ferenz. Additional and distinguished individuals have been invited and will inform us of their willingness in the coming weeks. What is the purpose of this project? The purpose is to dispel the myths and misunderstandings that have impeded robust and reliable cooperation between the United States and the ICC by bringing together all stakeholders on a regular basis to talk, debate, and educate each other about what the ICC is, what it is not, how it works, why it's important, and who it helps. The ICC project, we believe, will help secure both the court's future and the cause of international criminal justice. As we develop and implement initiatives in each of the project's 3 areas of activity that I've described, our principal objective will be to strengthen and broaden the U.S.-ICC relationship. Why is the ABA undertaking this project? As the independent national representative of the legal profession in the United States, enjoying global reach and stature, the 400,000-member ABA is well positioned to perform this leadership role. And the Center for Human Rights of the ABA, the association's core entity on human rights concerns, is well suited to implement this project. The Center is assembling key collaborators to inform and promote the ICC project, including the ABA section of international law and criminal justice, which will be directly involved in the training that I mentioned a moment ago, and academic institutions and non-governmental organizations throughout the United States. In conclusion, I conclude as I began, with words from Justice Jackson. These from his closing statement at Nuremberg. He said, "Of one thing we may be sure, the future will never have to ask with misgiving, what could the Nazis have said in their favor? History will know that whatever could be said, they were allowed to say. They have been given the kind of a trial which they, in the days of their pomp and power, never gave to any man." These words, the Nuremberg trials, embody the just rule of law that we seek and which the International Criminal Court represents. The International Criminal Court project of the ABA Center for Human Rights will say to those in the United States who may fear or doubt the ICC that the American legal profession believes in the ICC, that the eminent bipartisan members of the ICC Project Board of Advisors believe in the ICC, that support for the International Criminal Court not only serves the interest of the United States, but safeguards the values that we as a civilized people have long cherished, that we are comfortable with the court and its important role in the world, that everyone in America should be comfortable with the ICC and its work, and here are the reasons why. I invite each of you to join in that important conversation in the coming years. Thank you for your attention.
Thanks very much. I'll begin by posing a couple of questions to our panel and then opening it up to the audience for further discussion and questions. And if, when I turn to questions, I believe the mics will be on. But first, let me ask Professor Weiner, one of the things that's come up again and again in the conversations here are many of the policy reasons why it is in the interest of the United States to be engaged with the court. At the same time, in addition to these policy dimensions, there's a political dimension to it as well, and politics doesn't always have to do with good policy in a certain sense. And Ambassador Rapp brought up the Convention on the Rights of the Child. I had the privilege between college and law school of working on Capitol Hill for a while, and it fell to me as a junior Hill staffer to answer the phones in my senator's office. And this was in the early 1990s when the Convention on the Rights of the Child was being discussed. And there were several months when I had to answer hundreds of phone calls a day, following a script about the harm that the Convention on the Rights of the Child would cause to the U.S., that international bureaucrats were going to come, take people's children away from them, cause them to engage in all kinds of behaviors that their parents thought inappropriate, that was so completely disconnected from what the treaty actually contained, that it was not even a discussion of the policy rationales for joining it, but was instead an entirely different debate. So Alan, I wondered if you could talk a little bit about the political dimension and how it relates to the policy dimension of U.S. engagement with the ICC.
Well, I was nervous about being on the panel with Professor Martinez as the moderator because I knew the questions would be difficult. I was actually hoping for one of the other guys to be my moderator. Do softballs. I won't mention any names. So great question. I mean, your observation that politics doesn't always, produce good policy is, I mean, number one, it should. I mean, isn't that what we would strive for? But of course, it is inevitably the case. I also hope that, by the way, your script on the rights of the child phone calls included. In your case, ma'am, it actually might be a good idea for the international
Take your child.
Take your child away. Probably that wasn't in the script. It's a very difficult question, and I think the questions are big. I mean, the issue of trying to do sound policy generally, to have prudent, reasonable debate and figure out sensible positions that represent the best interests of the country as a whole. I think it's getting increasingly difficult to do that in our political system right now. And I think that it's in some ways especially difficult to do it in the foreign policy area, where for many people, particularly in the legislative branch, there's really very little cost of doing reckless things in the foreign policy area, right? There's not an obvious domestic constituency that is injured if you espouse a position which is jingoistic, which is in some ways harmful to the national interest, but there's no constituent who is actually going to call you up and complain about it. And I think these things are more challenging. That said, I've always been of the view that U.S. opposition to the International Criminal Court is an inch deep, a mile wide, but only an inch deep. I think there are reflexive arguments that people have about concerns, fears of loss of sovereignty, relationships with international organizations outside the United States, the vulnerability of our troops, which resonate in some ways with American people. But I think that opposition is actually really susceptible to pretty swift defeat if countered by the combination of two things. Number one is the interest-based story about why this actually is in the United States' interest to do. And number two, the story about the other kind of reflexive, more visceral values that would be reflected by a closer embrace of the ICC. When we supported the Nuremberg tribunals, I don't remember actually when we supported the Nuremberg tribunals, but when we supported the establishment of the ICTY, that was really couched in normative terms. People didn't make an argument about why this was good policy, it would be good for America, it would end the war faster, right? We said it's wrong. The concentration camps in Bosnia are wrong. The things they're doing there are wrong. And that's really a strand and impulse that is very powerful, that carries a lot of weight in American political discourse. And I think we just need to say it. I think we just need to start saying it. So I am of the view that there is also an alternative political story, an alternative political narrative, which could produce a greater support for the ICC, and I would love to see. I'd love to see our administration start. We're not going to send the treaty up to the hill now, by any stretch of the imagination, but to start making the arguments about why this is the right thing to do and would be good for America, rather than saying, we're not really ready to take a position. I think to take a position now would actually be the right thing to do and would contribute to the undermining of what seems to be a pretty strong political death grip against the court.
Jenny, may I comment?
Yes, please.
When I mentioned in my remarks that John Bellinger III has agreed to serve on our Project Board of Advisors, when I spoke with Mr. Bellinger in Washington, D.C. about a month ago, he was very quick to say I would serve on that board. And in our discussion, Alan just reminded me of something that John Bellinger said. First, this is my observation, a second-term presidency is more likely to result in the kind of courageous decision by the president to submit, not only to submit, but to use his capital on the Hill in making things happen. So that's yet another reason why this voter hopes that Mr. Obama is reelected. But as we were talking, John Bellinger said, he said, you are really an optimist, Mike. If you think that the ICC will enjoy the U.S.'s ratification, he said, I don't think it's going to happen in our lifetime. And I said, well, John, I only have one lifetime, and I'm going to do everything I can. And I said, if you pose the problem or the issue as the U.S. must ratify because it's the moral thing to do, because the requirement approach. I said, what if we approach whether someone on the street or a member of Congress and ask several questions? The first question would be, do you agree that a tyrant who commits genocide and murders people in his own country should be brought to justice? The answer to that question will be yes, unless someone is so out of it. Second question. The United States cannot bring that person to justice. We can't police the world, correct? That person will say, you're right, we can't possibly afford it. Third question. Do you think there's an institution, there should be an institution that will bring that tyrant to justice? Yes, of course. Do you know that we have such an institution in place at The Hague called the International Criminal Court? The answer is likely to be, no, I didn't know that. Well, we do. Let me tell you about the ICC. So you come not through the front door, breaking the door down, you come through the side door or the back door. Education is what I'm talking about. We have to educate, and that's what the ABA project is all about. We want to educate the members of our own government in a soft-spoken way about what we need to do as a moral people to protect human dignity throughout the world. We in the U.S. believe in that. It's in the execution that we have problems. But I think there is a way of explaining and educating members of our own government to get to the point, maybe it won't be in 5 years, maybe not in 10 years. But at dinner last night, I was reminded by something that President John Kennedy said in his inaugural, after laying out his agenda for the country, are these eloquent words, and I'm paraphrasing now. He said, we will not accomplish these goals in the first year of our administration, nor probably in the first 4 years, nor likely in our lifetimes, but we must begin. That philosophy holds true here. The ABA, after 40 years of adopting policies and eloquent resolutions, is now taking the first step into trying to put flesh to the policies that we've been adopting. And let's not kid ourselves. It's not an easy objective. It's not an easy goal. But I believe it can be done. And I hope it's in my lifetime.
Let me just follow up and to confirm what you're talking about on the crimes and on the dictators. I mean, we've already had the example of the way that people have responded in a bipartisan way on Coney. I remember when we were seeking the arrest of Charles Taylor, we went to the U.S. House and we got a resolution passed calling for his arrest in Nigeria and his transfer. I think the vote was 424 to 1. Only Ron Paul voting no. And so when you talk about the crimes, when you talk about the need for justice, you can and the conduct, the horrible conduct being committed by these individuals, you can build political support around a strategy. I think the challenge will be dealing with that in the context of the U.S. as a member of the ICC. Frankly, the I mean, I'm not a person who believes in American exceptionalism, but I've seen what American prosecutors have done, like at the Yugoslavia tribunal. If you go there now, you'll see actually 3 of them from the Bay Area, Alan Teeger and Mark Harmon and Pete McCloskey. Mark has recently retired, but these guys are fantastic, and they do the best job of anybody in the world because they can actually develop the case on the ground, because that's what American prosecutors, particularly in the federal level, do. They actually get down and develop the evidence and work with the police officers and agents, and then they're as good as any lawyer in the world when they go into court up against QCs from the UK or something. And so, you know, if we had Americans involved, and at the moment there are a few, but they tend to be dual nationals because the ICC appropriately gives a preference to countries that are paying the dues. But I've had many Europeans say, we really need you Americans in there, you know, rolling up your sleeves and your practical approach and all of that kind of thing. I mean, I imagine a day could come when, I mean, we had something like this when we had the Lockerbie bombing, and we would have liked to have prosecuted the guys in New York, and the English would have liked to prosecute them in Glasgow. We finally decided, well, we put the Scotch court in the Netherlands, et cetera. We came up with, because that was the only way we could get it done. And there could come a day when you've got a horrible situation, and you really need to have it done, and the only place that it can be done is the ICC, and the only way in which you can be assured that it's going to be done right is to get in there and be part of it. And so I think that's the kind of dynamic that could push something like this in the future. I mean, we don't know what the future holds, but in the meantime, I think the key to all of us is one, working with the court on a policy basis and developing, and on a case-by-case basis, developing this close relationship. And secondly, I'm really pleased to hear about your initiative, because this is democracy. You know, these things happen because the people want them done, and so mobilizing opinion and explaining this issue and exposing it, I think it's not going to be one with internal debate. It's going to be one like any of these treaties. I mean, when we've had tough treaties like Panama Canal, et cetera, it took a national campaign you had to organize, but begin now, and so, you know, on Barra, we'll see.
All right, I think we've got about 15 minutes left, so we'll open it to the audience for questions. And if you could, Ruth, come to the lectern.
I'm here, I get to Ruth, I was invited to be lying. So let me ask a question to Michael and to Alan. And I'm having lunch on Wednesday with Walt Slocum, so I'm just asking this to tell him I asked you. You know, Walt Slocum was the Undersecretary for Policy, Democrat.
Walt Slocum was a year ahead of me in college.
Was he?
Yes, but we haven't seen each other for many years.
Were you boxing
Give him my
partners?
regards.
He's a good guy.
Sign him up to your board. That'll be a challenge, though.
But I'll channel a little soft John Bolton, that's my excuse. He would argue, and Slocum would argue too, that the U.S., in its better moments, is a force for humanitarianism in the world, whether it's indeed supporting, well, we didn't support Rwanda, actually. We should have intervened in Rwanda, in my opinion, and we didn't. But in general, in our better moments, uses its military both for humanitarian intervention, for aid relief. We provided the logistics for Timor. We did Bosnia. None of the multilateral bodies work ever quite the way we would like them to. We don't run the world. So the Security Council doesn't always vote things we think they should. So we did the bombing in Bosnia without any new Chapter 7 resolution. We did the Libyan intervention without a Chapter 7 resolution. Could some legalists...
We had one in 1973, all reasonable means. Protect civilians.
Could some legalist make an argument that if it's not aggression, it's the unlawful use of force if you were a truly strict constructionist about Chapter 7 and Article 51? And secondly, just where I first entered I entered the law of war out of sheer curiosity, really, in the 90s, and was surprised to discover in how many instances our operational doctrine just differed from our allies. Whether it was Gulf of Sidra, when we would shoot back at a Libyan jet, technicals in Somalia, what kind of clearance you needed for particular kinds of operations. Ken Roth and his 15,000 feet. Is it wastrel misbehavior to bomb from 15,000 feet, or is it better behavior because you can take more time to choose your target carefully? And so I think and I say this as a friendly suggestion, I guess, in trying to push the project, be aware that there really are people out there who have heartfelt, well-founded, sincere, often factually based concerns about whether countries, say, that don't fight wars typically, like Europe, God bless, World War II is enough for a continent for a century, that may differ profoundly from us in operational questions. And it's very easy, being Americans, to translate our differences of view into questions of morals. So I think it's not going to be quite as simple I joked to Luis when he came to the ASIL, I said, you don't want us, because then people will think you're our stooge, and you want to be independent. And we'll cooperate with you, but you don't necessarily want us on board, lest people think somehow we're dominating your organization. But that joke to one side, if one thinks that having somebody to provide enforcement power ultimately is important to protecting vulnerable peoples, to deterring significant aggressors, then it's not wholly a matter of Manichaean logic to say that the folks who provide you the enforcement power are, making it up when they're concerned about their potential vulnerability. With European friends, all the time we have differences on discussions of use in bello, use ad bellum, and indeed, I'm very fond of Louise, known her a long time, but that committee where Fenrick did her great service in getting rid of that case on the NATO bombing in Kosovo, using the argument that criminal law requires that the norms be settled for a very long time, so that oil depots, electrical grids could be said not to be criminal because back in the World War II treatises, they were permissible targets. That was a close save. She needed NATO. She needed them for her mass graves. It was awkward. It was politically awkward. No one ever dreamed that the Yugoslav tribunal would be persistent time that long to cover an unexpected war. So my point only is that quite apart from how you try a case with a jury or a panel of your military peers, quite apart from the issues of countries' different attitudes toward the need for the use of force in contemporary politics, you're going to get a lot of good faith operational questions, which one worries, and here I'm delighted to meet all these good folks from the ICC, that the judges, and even some of the lawyers on the ICC may not be particularly cognizant of. I mean, that's why, if you're serious about this project, I would strongly urge you to get the ICC to have a NATO Military Advisory Council, again, to make sure that military judges who have operational experience are part of the panel, and to address openly some of the good faith but profound differences on operational law. Last joke is, my friend Harold is very much surprised, I suppose, to be attacked from the left by Philip Alston on drones, because one is used to being on the correct side of issues, so to say. But even from the stance of the Obama administration, I would say the bulk of Europeans are probably deeply critical of the use of drones. And it's very easy to translate a difference in judgment into a more profound condemnation using criminal law. So it ain't easy. And I also think, which was the intent of my comments this morning, that the more that one can be frank and honest about what's working right and working wrong at each institution. We can't do this as sort of a utopian, wishful wish fulfillment. The court has to work well and optimally in order to make it a plausible sell to the American people, American Congress.
My answer is yes.
Mine is maybe.
Any other reactions?
really gonna-
or-
Well, so let me just say, I mean, obviously, Ruth, some of the things you touch on are precisely some of the points that I tried to address. I mean, I think that, first of all, a lot of the comments that you began with really focused on recourse to force, resort to force, use ad bellum, right? And yes, I know there is a possibility that we could make an argument that any unlawful use of force could be styled as a crime against humanity. It's a project that is of interest to Mr. Ferenz. We've talked about it, but I think that is not a conventional view, right? And the conventional view, I think, is that recourse to force questions would fall within the definition of aggression, which the United States has and certainly would opt out of if it were able to join, if it ever decided to join the ICC. So we're not going to be looking at the legality of our use of force in Iraq in 2003 or the Kosovo intervention in 1999. No, I don't trust them for, it's not the court I don't trust for ad bellum. It's not the court, it's America I don't trust for ad bellum. Right? In other words, I expect that the United States may well reserve the right to violate a conservative black letter law reading of the UN use of force regime. So it's not that the court will misapply the law that would cause the United States to treat the ad bellum and in bello issues differently. It's precisely the danger that the court would accurately apply the law and that we don't want to live with the consequences, right, that would cause us to treat them differently, right? And I think any prudent president would say, we, in the matter of the service or national interest, have to reserve the right to use force in some circumstances where it may not be defensible under a centrist reading or a conservative reading of the UN Charter. So that explains that. The other thing I will say is the operational issues, I think, are hard, particularly, again, if we're talking about, again, what I described as kind of the level of operational policy as opposed to targeting decisions that corporals and sergeants are making and privates are making on the ground, rules of engagement type issues. The one thing, though, we need to be realistic about, look at all of the cases in the Rwanda Tribunal, look at all of the cases in the Special Court for Sierra Leone, look at all of the cases in the Yugoslavia Tribunal. How many of those involve conventional military like targeting decisions?
The
master law.
Yeah, so, and that's what these cases are about, is the wholesale slaughter of civilians and the mass rape of civilians. The only exception is the siege of Sarajevo, right, where you might actually have a debate.
Case, yeah.
Say it again?
And Operation Storm and Flash.
No, because the Storm case was about the wholesale slaughter of civilians in the court. It was not about the legality of the operation.
No, I understand, but I mean, part of it does involve the shelling of Knin, which is an important legal issue. Will be debated next week.
Okay,
Yeah,
okay.
right.
So actually, it's not Storm. It's actually what was his name? Markic. The shelling of Zagreb. Right, so the Markic case, right? But again, this is lobbing missiles, right, into urban centers for the purpose of causing destruction of civilian targets. I mean, these are not close operational issues. So I do think that while these are really interesting issues, and I love talking about them and teaching them, but I think about this, I mean, there's a lot of stuff in the morning when you get up that's hard. And, sometimes it's easier to stay in bed because if you get out of bed and you do stuff, there are risks that bad things could happen, right? And I think that there's a way when we talk about those kinds of scenarios, yes, they are risks, but for me, I'm a lawyer, right? I'm trained to advise my clients about managing your risks, because I was a practicing lawyer before I was an academic, right? And I think, again, the position I took is not that there's no risk here, but that they're manageable risks, and that on balance, it's in the interest of the U.S. government to pursue this course of action.
I would add only that I'm very encouraged by the fact that the three organs of the ICC have spoken today, and that each of them has indicated honestly the strengths and weaknesses of the court on its 10th anniversary, things that the achievements, the misfires, the problems that need to be addressed, and a willingness to address them. I think that's very important. For those in the U.S. who say, my gosh, 10 years, this is it? That's all we have from the court? Never mind that the U.S. has been on the sidelines until very recently, as we heard the ambassador say. One wonders where the court might be today if there'd been not even ratification, more support going back 10 years instead of the last 2 or 3 years. John Bellinger told me that when Bush was reelected, the decision was made to soften its stance, the administration's stance with respect to the ICC. And Bellinger spoke proudly of that administration was moving closer. The Obama administration is moving even more close to what needs to be done. When I said I say yes to what you were saying, I was wondering whether there was a question in your remarks. But I do agree with you. Who can question the good faith of people in our country with whom I disagree, but their good intentions in making sure that our young men and women who are protecting our country are not subjected to trials as war criminals or whatever because they were performing their duties? No one would doubt the good faith of the speaker saying that, nor would doubt the valor of our servicemen and women. I don't think that's the issue here. The issue here is bigger. Is there a need for an international criminal tribunal? I say yes, there is. And it's our job as lawyers at the ABA and all of us to, again, educate, the word educate. And if that doesn't work, then it doesn't work. But as I said earlier, I think it'll work in time. Because there's going to be a comfort level. When people see what the court has done, and that the risk of harm internally is minimal, maybe not totally non-existent, but minimal, it can be managed, as Alan said, I think that's when we start changing attitudes.
I think we have time for one last question. Anyone else? Over there, if you could come to the mic, please.
Stefan Sonnenberg. I guess I have a pretty short question, which is, are we encouraged to support the ICC only if and when it never would damage the interests of an American citizen or an American institution? Or could there be instances where the ICC could legitimately actually prosecute somebody who is of American descent?
I touched on it because obviously this is the concern that they might prosecute an American who doesn't deserve to be prosecuted is the reason that we're not at this time going forward. And obviously if we have an American that goes out and kills 50 civilians intentionally, we want to see that individual prosecuted. And if for some reason there wasn't, there was a case and we weren't doing it, then obviously we want to make sure that justice is done. But of course it's fundamental within our law and within the system of the ICC that it would be our obligation, and I believe we do it, and that we wouldn't get ourselves into a situation if we were a member of having a legitimate case taken against us.
I just would add that if you think the politics of getting support for the ICC are hard, if you want to argue, if the debate is whether or not it's in the national interest, the ability of trying to get support for the ICC, if you're going to argue that it's going to be contrary to the interests of the United States or American citizens, this is an area where pragmatic considerations, I think, are obviously very important to bear in mind.
All right, with that, I think we'll hear some closing words for the conference from Alan.
So thank you very much. We have come to the end of our appointed time. The conference schedule, I'm being looked at by Sasan as if I've done something horribly wrong. I was going to say a few words. Okay, just one moment. I'd like to invite Sasan. What I meant to say is, allow me to present the Sasan Samshoman.
I'll start with a caveat, and that is that I'm not as close to being as articulate and well-spoken as all the panelists you've had. I just have a few words. I know you're all tired. It's a beautiful weather outside. You've spent your whole Friday with us. Just a couple of words of thank you. And allow me to start with my dear colleagues from the International Law Society and the administrative staff here at Stanford Law School who have really worked hard in the span of the last month to try to put this together. And I wanted to thank you, all of you. It's been a pleasure working with you, and thank you for all your efforts. And of course, I would be remiss if I didn't give due and heartfelt thanks to Professor Alan Weiner, whose genuine commitment to his students, to Stanford Law School and to international law is really what brought us together here today. So he definitely deserves a well round of applause, and I thank you very much. And of course, our distinguished guests. They've traveled far and wide to be here with us today. I'm most grateful. I think you would agree with me that we're all privileged that we have the pleasure of having them here. And thank you to all of you for making the time to be with us here today. Our co-sponsors, the lovely Indian lunch that you enjoyed we had it by virtue of their generous contribution, from the American Bar Association to Planet Hood Foundation, the American Society of International Law, and others who've been very generous with us. We thank them for their contribution to this conference. Of course, our moderators, Professor Jenny Martinez, Professor Quillar, and Professor Helen Stacey. You have to understand here everybody smiles because it's sunny, but everyone's extremely busy. And they've all taken their time out of their very busy schedules to spend some time with us. So we really appreciate their contribution, and thank you. Thank you once again. And of course, last but not least, I want to thank all of you. Again, I know you're very busy. You have very busy practices, and some of you have traveled quite a distance to be with us, so thank you for your interest. You've heard here today that the court has traveled we've traveled a few miles, but we still have a long journey ahead of us. I hope that you stay committed and that you support us as we continue on this arduous and challenging journey. So thank you again for your interest. Allow me just to give a quick thanks to Michael Greco and the American Bar Association and my dear colleague Kip Hale for their courageous stance and this wonderful new chapter of engagement that you want to engage with the ICC. I think you are to be commended for that, and all the best to you. And if you can contribute modestly to that effort, we'll be happy to do so. And I speak on behalf of the registrar, the vice president, and others, if I may, as you have engaged in this wonderful effort. I think that's pretty much it. The last comment I want to make, I just wanted to say to the ICC, happy 10th year anniversary. Thank you very much.